Deputy Minister Sarupen or the Minister himself. They are welcome. If there's the DG or executive officials from National Treasury, you are welcome. SARS, FIC, and all other entities that have been invited are also welcome, and welcome our support team from SCOF, the media. Do we have apologies?
Yes, Chair. Apology from Mr. Lekhanyani. He's writing an exam. Ms. Taleka Mazibuko has to leave at 10 to attend the preparations. And then an apology from DM Sarpan. Thanks, Chair.
Okay. Thank you. Those are the apologies. And then let's move to item 3. The next item. Flight the agenda again. Yeah, there we are. The purpose of today's meeting is to get a briefing from National Treasury on the general laws anti-money laundering and combating terrorism financing amendment bill B15 of 2026. There is a background to this matter. It's not the first time that we deal with a general laws amendment bill. I remember last time in the 6th Parliament, we dealt with this bill because it was, by then we're having a lot of pressure that South Africa was grey listed, and we had to comply with some of the requirements that were put by FATF to South Africa to look at. We worked tirelessly because at that time we even had a very tight schedule to process that bill. And we did, under very tight schedule, process the bill. The bill passed and it was assented to by the President. And the country later was removed from the grey list. And if you remember, it was dealing not only with bills that have to do with this committee or finance department and the Standing Committee on Finance. It was also affecting other departments, and that created some bit of tensions that were like a super committee that can amend bills that affect other departments. But we dealt with that politically to demonstrate that we are not a super committee of Parliament. It was just that at that time, there were issues that the country had to comply with. The country complied, and so now we see, now Treasury, you are bringing another bill when we have passed the bill previously. Please explain to us in detail what is this new bill all about when we had passed a bill initially. And I remember by that time, DDG Momoniat Ishmael was the one who was leading the process. And even after his retirement, the minister kept him I think, on a contract to finalize certain issues that were outstanding that have to do with FATF. So we'll want to get a thorough briefing today, because I know the process last time was not easy, because it was a transversal kind of a bill that was not only affecting one department. So look at that background and give the rationale of this bill that you are bringing now, and how you expect us to process it. Does did FATF raise new issues with you, or is it you who wants to tighten certain things that you think are not tight enough, and all those matters? I say this because of the background that I have with this matter. So over to you, National Treasurer. Thanks.
Good morning. Thank you very much, Honourable Chair. Good morning, Honourable Members. Yes, we will try and go through the different slides for you to try and explain why we are back after you've passed those previous General Laws Amendment bills. If I can start, can you see the slides?
Yes, I can see this now.
Great, thank you. So just to start, I'm Chris Axelson, the DDG for Tax and Financial Sector Policy at the National Treasury. I will be the person going through the slides, but there is a much wider team that is behind me that are in the meeting that would be able to assist with a lot of the technical questions. We have two presentations this morning. The first one is about the mutual evaluation and part of the reason for why we have another General Laws Amendment bill. And the second presentation will be done by Puvendri at the FIC, and that is on the clause by clause of the bill to go into the detail of what it is trying to do. As I said, there's quite a big team. So there's officials here from the National Treasury, from the Financial Intelligence Centre, including the director who is at the FIC, the SA Reserve Bank, the Financial Sector Conduct Authority, and colleagues from DSD, DTIC, and CIPC. All of these are in the interdepartmental committee that deals with these matters. As you said previously, these bills are quite cross-cutting. They bring in a lot of different departments because there are different issues that are required in terms of the FATF standards, recommendations, and immediate outcomes. So if I go to the next slide, the previous bills did a lot of work to help get us off the grey list from FATF. It is a bit of a coincidence, but we are immediately back into the mutual evaluation process. So we have to go through this process to avoid being grey listed again. This mutual evaluation process is about an 18-month process, and it's already started. There's been training from February to April. FATF have helped us with that. ISAMALEG, the Eastern and Southern African Anti-Money Laundering Group, have also assisted with that. And there are two components to this mutual evaluation. There's the technical compliance, which looks at the legal framework and the institutions, and there are 40 FATF recommendations there that we need to pass. And then there are effectiveness requirements, and those are done through 11 immediate outcome measures. And I'll go through the details of those as well. So we do think the process would end around October 2027. So this process in terms of getting through the mutual evaluation is already well underway. We have continued with Momo that you mentioned, Chair, who is on the call as well as a consultant to assist us with this after getting us through the grey listing on the last time. But this process is well underway. The key reporting deadlines that we have for the FATF mutual evaluation are the first reports that we need to give to them on the 27th of July, and then there's another report on the 19th of October. They are then planning an on-site visit where they come to the country from the 2nd to the 19th of March next year. And then they will be putting forward a report that will then go to the plenary in October and published in November 2027. So a lot of those details are on their website. The reports themselves and the process and what they do, other than the dates that obviously we've just disclosed, are highly confidential, and countries aren't allowed to release any details about their engagements with the FATF assessors. So we need to be very careful about what we disclose publicly. For that reason, Treasury is usually the only sole spokesperson on this. So we need to be very careful that we don't disclose any confidential information. They are quite tight with the information and what they do in terms of FATF. Only when they come on the on-site visit do they then meet external stakeholders. The process to exit the grey listing, as I said, has already gone through, and it will help us. We've gone through a lot of the same types of recommendations and requirements that are needed in the previous grey list, so it'll be fresh and top of mind for a lot of the officials that have dealt with this issue. But unfortunately, the mutual evaluation is slightly different. It's a new methodology, it's wider, and it's tougher than the old evaluation. So there are new things that we need to do. They will have a deeper look into what we have done to try and get past this. So just because we passed the grey list previously doesn't mean we will automatically get through the mutual evaluation, because the methodology is more difficult. For example, it's going to have a deeper focus on risk-based effectiveness and outcomes. It expands the assessment of risks such as crypto assets and other types of fraud and corruption. And they look for a stronger integration between the technical compliance and the effectiveness. There's also greater use on data, statistics, and case studies. The technical compliance, Chair, is very much linked to those previous bills that were passed about getting the regulations and the institutional setup in place. And that's part of what we need to do. But that now needs to link with the effectiveness framework. It's about, well, yes, you've got the rules and regulations in place, but are you actually implementing them? Are they actually working or not? And that's what they'll look at in more detail in this mutual evaluation. The technical compliance, we don't think this poses as much of a grey listing risk because of those previous bills that were passed and a lot of the work that was done in the previous administration. South Africa actually did largely comply with 38 of 40 FATF recommendations where the one wasn't applicable. So there are two recommendations 8 and 32, which are only partially compliant. Those relate to NPOs as well as to cross-border cash movement. So we're going to be assessed again on this technical compliance, even though most of them are largely compliant. And the two recommendations, 8 and 32, which I mentioned, which aren't largely compliant, will be assessed, as well as at least 12 other recommendations. So the recommendation 32 on the cash couriers, it won't require new legislation. We actually gazetted a new framework for that in the last couple of weeks. So that should be covered through that gazetting of those regulations, but we would need legislative changes for recommendations 8. So we don't think we would get grey listed just because of the technical compliance deficiencies, but we do need to try and improve them as much as we can because they will help with the effectiveness measures on the immediate outcomes. So this bill that's being put forward, part of it is really to try and help us on these technical compliance recommendations so that we can improve them and then get a better outcome on the effectiveness rating. So this bill would then amend the 4 acts, the NPO Act, the Companies Act, the FIC Act, and the FSRA Act. There are some measures here that are not in this bill that are not aligned to the FATF. So there are some additional measures that are put in place to help with countering corruption. So this shouldn't be seen as only an a FATF mutual evaluation bill that is being put forward, but there are measures in the bill that are trying to help us on that. But we thought it would be useful to update the committee on this process as well as we get into it. If we go to the next slide, we think the main grey listing risk is probably around effectiveness. There are these 11 immediate outcomes that we need to meet. They've got 4 ratings: low, moderate, substantial, and high. If we get grey listed, we don't get immediately grey listed, but you get referred to FATF's ICRG, which is the International Cooperation Review Group and post-observation process at the plenary. Then you'll have a very short period to try and turn things around before you do get officially grey listed. So it is quite difficult to get out of it once you do get referred to that group. So to make sure that you don't get referred into that ICRG, you need to only get 1 immediate outcome that's rated as low out of the 11, or you need at least 3 immediate outcomes that are substantial effectiveness if a country gets more than 1 low. So if you get 2 to 5 lows, then you need at least 3 substantial effectiveness to avoid going to the ICRG. Because it's now based on a risk-based approach, and that's an important measure, we need to update 3 national risk assessments. So on money laundering, terror financing, and proliferation financing. I'll get into that. It's about immediate outcome 1. We also need to be quite careful to show the effectiveness statistics over 5 years. So a lot of what has happened and what we are doing for this mutual evaluation in terms of effectiveness, it's already happened in the past. And now it's about getting that data together and putting case studies together and showing the story that it's improving. Okay, in terms of IO1, immediate outcome 1, this is about risk coordination and policy. So it's making sure that you've assessed the risk and that you are coordinating between the different institutions. The main way to get through this is to do the national risk assessments, which I mentioned, on money laundering, terrorism financing, and proliferation financing. Once there is a good risk assessment on those, they can then assess, the FATF can see whether you have assessed the risks correctly and have you coordinated, have you coordinated between the institutions to be able to assess those risks and act upon them if required. So we are hoping to put those together and potentially publish them in August. In terms of IO immediate outcome 3, that's based on, have you got the correct supervision in place? So this is really focused on the financial sector regulators that are there. So the Prudential Authority, the Financial Surveillance Department, both at the SARB, the FSCA, and the FIC. Are they in place? Are they effective? Are they able to supervise entities in terms of looking for money laundering, terrorism financing types of risks? Immediate outcome 4 is on the other types of regulators that also look at different sectors. So here, FIC plays a leading role in terms of their supervision on other actors, because they're not banks, they might not be other financial service authorities that are, or institutions that are regulated by the SARB and FSCA. So this is about ensuring that there's a broader scope of actors that are then assessed for their risks for money laundering and terrorism financing. So it includes legal practitioners, estate agents, metal dealers, gambling institutions. So it's these 2 immediate outcomes are really trying to say, are those institutions able to supervise these entities and these agents, and are they able to do it in practice, and are they effective in doing it? This will now also include, for the first time, crypto, which the FSCA have started to supervise, as well as the FIC, and they are under that supervisory that framework. And it's about trying to take action against illegal cross-border activities, for example, through FinServe. So the next 5 measures just to discuss are on money laundering effectiveness. The first one, IO2, is about international cooperation, and it's whether you are both asking for mutual legal assistance from other countries and assisting them. So on money laundering requests. Then the others, IO5, is about beneficial ownership, where part of the General Laws Amendment Bill that we're putting forward today is trying to assist with. IO6 is about trying to show that the financial intelligence that you receive, you're actually using it effectively. IO7 is about the investigations, the prosecutions on money laundering. Are you investigating money laundering cases? Are you being able to prosecute those? Can you show case studies, and can you show a trend? And is that trend increasing? And IO8 is about the seizure of assets. So have you shown that you've confiscated some assets in relation to money laundering cases, as well as foreign proceeds that are illicit? Here it really will be about statistics and case studies. The next three for IO9, 10, and 11 are all about terror and proliferation financing. So it's IO9 is about terror financing. Do you have a policy to deal with this? Are there resources allocated to this? What are the risks from MPOs? So it relates to recommendation 8 on the recommendations for technical compliance that we're trying to deal with in this bill. IO10 is about financial sanctions. Are you implementing those financial sanctions for suspicious actors? Are they targeted? Are they effective? When you do get sanctions from the UN, are you disclosing those immediately and making sure that the financial sector is acting on those sanctions? And then proliferation finance is about, is there cooperation on WMD financing? Are you assessing this? Are you checking for the risks? And is there any enforcement if you find any issues? So that is a sort of a quick overview of what the mutual evaluation is trying to assess with those 11 immediate outcomes, as well as the technical compliance issues. So how are we dealing with this? We do have an interdepartmental committee that was established to coordinate the process. And that was confirmed by Cabinet in August of last year. So it continues on from the process that we used to exit the grey list. And it comprises a lot of departments and a lot of different officials, because this is such a cross-cutting matter. You can see all of those are highlighted in the second bullet point. It also consults with gambling regulators, other info regulators. I was changing the wrong slides. I hope the members were able to see the slides and they have a copy of them. But I will continue. So the Interdepartmental Committee also reports regularly to the JCPS, as well as there is a ministerial oversight committee that has been set up to look at this. Okay, in terms of the bill itself, it was introduced in Parliament in May. As I mentioned previously, it means 4 acts: the MPO Act, the FIC Act, the Companies Act, and the FSR Act. So it does deal with those MPO issues in terms of recommendations 8, which I'll just highlight before Puvendri gets into the clause by clause. So we were partially compliant on this recommendation in 2024, and it asked for countries to have a focused, proportionate, and risk-based measures on the MPO sector. So FATF don't want a blunt instrument to knock all MPOs because there might be terror financing risks. There needs to be a risk-based approach to these types of MPOs. So they don't want it to be burdensome or restrictive on the entire MPO sector, but as a government, they need to assess the risks and then apply actions to those based on what those risks are. So the previous deficiencies were saying that not all MPOs were exposed, were covered by the MPO Act, even though they potentially could be exposed to terror financing risks. And it didn't prescribe fines or imprisonment for non-compliance, and there was no enabling mechanism for action when there were suspicions. What could you do based on the law if you had suspicions of this? So this bill tries to change those so that we can hopefully upgrade to being largely compliant on recommendation 8. This is just some background on the MPO sector. I mean, there are 400,000 MPOs. It is done by the DSD. The MPO Act does require mandatory registration if you have cross-border activities, whether it's donations or whether it's you're providing services outside of South Africa. The DSD registers these MPOs, and they have a dual mandate. So it's about developing as well as ensuring regulatory compliance. So the previous assessment identified a couple of these risks, which we're trying to deal with here. And we just need to try and make sure that that is done on a risk-based approach. There are some other additional amendments in this bill to try and fight corruption. So it's about empowering the FIC to more effectively fight that corruption. One of the issues that has been found is that there is a shifting of funds between banks, and it's then difficult for the other banks to assess whether this is an illicit flow of money or not. And at the moment, it's a little bit unsure whether they are able to do that according to the legislation. So the amendments here are trying to make it clear that you can share information on a confidential basis between banks and other accountable institutions so that you can then follow the flow of these illicit funds. And it'll be easier to then identify these and create suspicious transaction reports. And this is generally done, this coordination and cooperation is done through the SAMNet forum, which the FIC can talk about later if required. And this amendment allows that sharing of information to then more effectively follow that flow of funds. So the provisions here to strengthen, I'll leave a lot of this to Puvundri because she'll go through a lot of these details. But you can see it's about allowing the sharing of information, making sure the staff and directors aren't prosecuted if they are complying in good faith, the ability to conduct lifestyle audits for public sector appointees and to share that information with other relevant organs of state, and for the FIC to be able to access more databases and registers from all organs of state. In terms of the FSRA, there are a couple of other amendments here about financial products, licensing powers, beneficial ownership, which I did mention in terms of IO5, which is required, and other contraventions, as well as a resolution framework. So this is slightly different to the FATF issues, which Puvundri will go into. On the beneficial ownership as well, this is the Company Act amendment. So this is going to allow and try to improve the accuracy of this beneficial ownership, which will help with FATF issues. So it's about saying that the CIPC do need to get this beneficial ownership. If banks find out that the beneficial ownership in the registry is different, they can report it. And as well as allowing the CIPC to impose fines if companies fail to submit or update their beneficial ownership or submit false information. So just to conclude, this new mutual evaluation process has already begun. So the first few reports are due in the next couple of months and then in October, and then we'll have an on-site visit next year. There are, the risk is really from effectiveness. We're hoping that technical compliance from the legislative and regulatory environment is pretty low, but we do have to work on showing the effectiveness and the improvements in our effectiveness over the last 5 years. This bill will help us with recommendation and other technical compliance assessments, which will then also help us on the effectiveness measures because there is a greater link in the new mutual evaluation process. And we hope it will assist in making sure that we don't get onto the grey list in October next year. I will stop sharing, and I hope Puvundri will be able to share from her side to then go through the clause by clause. Can we go directly to the clause by clause, Honourable Chair, or would you want to stop for some questions?
Take the next presentation so that when we come to questions and comments, we deal with all the issues at once because they are related.
Thanks, Honourable Chair. Puvundri, go ahead.
Good morning, Chair, and good morning, honourable members. If you just give me a second, I'll just share my screen. I see that I'm disabled from sharing my screen. I'm not sure if Alan can.
I've just given you that.
Yeah. Okay. So just in terms of some background to the provisions that I'll be going through, as Chris mentioned, this stems from the mutual evaluation process. And following on that, when the country was placed in the two remedial processes by FATF, which was the enhanced follow-up process as well as the grey listing process, there were additional deficiencies that were identified that was not addressed during the previous General Laws Amendment Bill. So the proposed amendments that we are putting forward will address these technical deficiencies that arose during these remedial processes. So the bills, as Chris mentioned, would be the Close Cooperation Act, as well as the Non-Profit Organization Act, the Financial Intelligence Center Act, the Financial Sector Regulation Act, as well as the Companies Act. Okay, I just want to double check that my screen is showing the correct slide.
No, it's still on the title screen.
Okay.
And you might want to put it in presentation mode.
Okay, just 1 second.
I also struggled with this.
Is it now showing the correct slide?
It is.
Yeah, okay. I just want to check if I could get to presentation mode.
Where is the problem? Is it
Um,
the sound or what is the problem? Or is it sharing the screen?
it's the sharing. I can't seem to get it into presentation mode. Is it fine if I
Alan, can you assist from your side?
Would it be fine if I share it like this, or?
Alan, Butle.
Yes, Chair, I'll share from my end. If she can just take it off the screen and just indicate next slide. Thanks.
Okay.
Okay, I've stopped sharing. Okay,
There you go. I think you can go ahead, Bhuvanju.
Okay, you can move to the next slide. Next slide, please. Thank you. So the proposed amendment to the Close Cooperation Act is a consequential amendment following on a proposed amendment to the Companies Act that will require discrepancy reporting. That is information that is held by obliged entities, for example, an accountable institution, and they would compare that information that they've obtained during the customer due diligence process with information that is held at the CIPC Beneficial Ownership Register. But I'll go into more detail when I discuss it as part of the amendments to the Companies Act. Next slide, please. The proposed amendments to the Nonprofit Organization Act, this follows on the amendments that were made in 2022 in respect, more specifically around the monitoring and enforcement of nonprofit organizations that are required to register in terms of the Act. There are additional measures that strengthen some of the monitoring requirements. This is a requirement in terms of recommendation 8, which requires NPOs that are at risk for terrorist financing to have certain measures in place to ensure that there is accountability, as well as that they are properly registered with the NPO Directorate. So the proposed amendments that we have in terms of Clause 2 is to make sure that the NPO Directorate, there is a clear mandate that one of the functions is to monitor and enforce for compliance with the NPO Act by NPOs. The second proposal is in relation to administrative sanctions. The 2022 amendments to the NPO Act allowed for the director to impose administrative sanctions. And these are just provisions that make sure that it is clear enough in terms of the instances when the director is able to impose administrative sanctions, as well as ensuring a fair process by allowing for the arbitration tribunal to hear matters of NPOs who are dissatisfied with an outcome of the director imposing certain administrative sanctions. Another proposed amendment that deals especially around ensuring that the sanctions imposed, and this is criminal sanctions, not the administrative sanctions, because this is also one of the deficiencies that was identified during the follow-up process, is that the Act is not clear in terms of the amount of the fine that can be imposed, as well as the years of imprisonment, to ensure that the sentences that are imposed by a court is proportionate and dissuasive. So the proposed amendment here is to add a maximum penalty of R1 million and 5 years imprisonment for criminal offences that have been committed by an NPO. Next slide, please. The proposed amendments to the FIC Act, again, some of the proposed amendments, although they may not directly linked to specific deficiencies in the follow-up process, they do assist from an effectiveness point of view throughout a number of immediate outcomes, as well as ensuring that the FIC has sufficient tools so that the end product that eventually goes to law enforcement is of a usable and of a good quality. So the first amendments that relate to amendments to the definition in the FIC Act, which includes, for example, definitions of the Public Procurement Office and the Border Management Authority, as well as the lifestyle audit. These definitions were necessitated because of the provisions that we are proposing in the amendments to the FIC Act. So in terms of the adding entities to whom the FIC is able to share intelligence information in terms of Section 40, there has been a need for the Public Procurement Office to be included as one of the entities that the FIC is able to share information with. And again, this specifically speaks to the issue around the procurement fraud and corruption. And also the inclusion of the Border Management Authority. This arose mainly with the implementation of Section 30 of the FIC Act, which deals with the reporting of cash at our borders. And then another proposed amendment in Clause 7 is the conducting of lifestyle audits. This is, again, a specific requirement or a proposal that stems from the one of the tools in terms of fighting corruption that Chris had mentioned. So although the FIC is currently able to perform lifestyle audits with its current analysis functions that it conducts, we are now also making it clear in the legislation the instances in which the FIC would be able to conduct lifestyle audits, which would include while it is performing its functions, as well as when it comes to persons who are listed in Schedule 3A of the FIC Act. Schedule 3A lists the domestic politically exposed persons. So these are the persons that are holding those public functions, and there is a specific list in the FIC Act. It can also, the FIC would also be able to conduct lifestyle audits in instances where there is a request from any organ of state, a public entity or a municipality, and also if the FIC believes that these organs of state have an interest in such a request. And then in terms of Clause 9, this is a current provision in the FIC Act. This it's just extending the types of entities that the FIC is able to request information from, and this includes any public entity or municipality. Where the FIC also is the amendment here is also to extend the access that the FIC can request information when it relates to a register that is kept by any organ of state, public entity, or any municipality. As I've said, these are current provisions. This is just strengthening the current provisions by ensuring that the FIC would be able to have regular access to these registers, and it also extends to public entities and municipalities. Next slide, please. Another proposed amendment to the FIC Act relates to the record-keeping requirements by an accountable institution. Currently, an accountable institution is required to keep certain information that it receives from its client relating to customer due diligence measures as well as transactions. Currently, the FIC Act requires accountable institutions to keep this information for a period of 5 years. The proposal here is to extend that period to 7 years. The next requirement or proposed amendment deals with targeted financial sanctions. This again is a specific technical deficiency that needs to be addressed, and this relates to the UN Security Council Resolution 1373, which requires a mechanism for a country to have a mechanism in place where the assets of a person can be frozen if they are suspected of terrorist financing related activities. And in terms of Section 23 of the Poctotara Act, there is a process or an order that can be applied for by the NPA to a high court requiring or asking the court for the assets of an individual or an entity to be frozen, or to implement an order or a request that comes from a foreign jurisdiction for a person that is in the country. So once an order is made, this proposal is allowing for the director of the FIC to issue a notice alerting accountable institutions of the order that is made, as well as the names of the individuals, so that they are able to scrutinize their client list to see if they have a client that is impacted by the order that is made in terms of Section 23 of the Poctatara Act. The next proposed amendment deals with, again, a deficiency that we specifically are addressing, and it relates to Section 26C of the FIC Act, which allows the minister to permit certain financial or basic living expenses that an individual who is listed in terms of a UN Security Council resolution, that this also there was a deficiency in that the specific list of transactions that a person can still conduct did not include extraordinary expenses. So this is just a technical amendment that includes this as one of the considerations that the minister can make when he's determining whether an accountable institution can continue with a transaction with a listed person. Next slide, please. The other permitted service is also the accrual of interest or other earnings that arose after or before the person was listed. Again, this is addressing a very specific and technical deficiency. The proposed amendments to clause 15, again, as I mentioned, extend to the court order that is made in terms of Section 23 of the Poctatara Act. This just requires the accountable institution to scrutinize their list of clients to see that they are not transacting with the person that is mentioned in that court order. The other amendment is also, again, a very technical or addressing a specific deficiency where the accountable institution would also need to report to the FIC any attempted transaction or where an listed entity is inquiring or making inquiries about his account, that this needs to also be reported to the FIC. So this is these reports specifically relate to the targeted financial sanctions regime. Next slide, please. The proposed amendments to Section 27. This Section 27, again, is a current provision in the FIC Act that allows the FIC to inquire or request from an accountable institution certain information, such as whether a person is a client of an institution or whether a person is acting on behalf of a client. The proposed amendments here extend to the FIC being able to ask information about the type and status of the business relationship, as well as information on the date that the business relationship commenced or terminated. And it's the same when the FIC might have an account number, but might not have other information. So this provision would allow the FIC to ask information from an accountable institution or any person who has the obligation to report a suspicious transaction. In terms of clause 14, this amends Section 27A. This again is a current provision that allows the FIC to access records that are held by accountable institutions, and this can be done on a warrant. And this is extended to instances where it involves the producing of forensic evidence, or for the FIC to be able to conduct lifestyle audits. Next slide, please. The proposed amendment to in clause 16 is related to section 30 of the FIC Act. This section is the reporting requirement for every traveler that enters or leaves the country to report to a SARS official an amount that is prescribed by the minister. While this section will only come into operation on the 1st of July, the proposed amendment here is that because the information needs to reach the FIC without delay, there is a proposed amendment that the time within which the SARS official reports to the FIC the information that they receive from the traveler will be set out in terms of the regulation. And the regulations then set out that this needs to be done within 2 days. Then the amendments to section 35. This again is an existing provision that allows for the FIC to obtain a monitoring order, and this usually is done through approaching a judge that is appointed in terms of the RICA legislation. And due to the practicalities that there are some instances where that position is vacant, or if there is an urgency in it, the proposed amendment here is to remove the requirement that it be a judge appointed in terms of RICA, and to have that order being heard by a magistrate or a judge within the jurisdiction where the accountable institution conducts its business. Then the proposed amendment to clause 18 deals with amendment in section 38. Section 38 allows some protection to persons who have obligations in terms of the FIC Act. So if they are acting in good faith, then no criminal action can be taken against such persons. The provision is amended to extend this not just to an accountable institution, but the protection also is extended to directors or employees that are acting in good faith. And these are also for instance, instances where the accountable institution is required to make a regulatory report, like a suspicious transaction report or a cash threshold report, or when it shares information between accountable institutions, and that would assist in contributing to a more a better regulatory report. But I'll speak about that in the next slides that are coming up. The next slide, please. The proposed amendments to section 40, this section specifies the agencies with which the FIC is able to share its intelligence information with. And the proposed amendment here is to extend the sharing of that information to the organs of states and the public entities and municipalities in instances where the FIC has conducted a lifestyle audit at the request of these institutions. As well as I had mentioned earlier that we are proposing that the list also be extended to the Border Management Authority as well as the Public Procurement Office. The proposed amendment to clause 20, this specifically allows for the accountable institutions to share information before they file a report with the FIC. While this is a current provision, the proposed amendment here is to extend it. Initially, it was confined to suspicious transaction reports. This ability now extends to all regulatory reports, as well as instances where the FIC is able to request information, as I mentioned in sections 27, as well as in section 32, which allows the FIC to ask for additional information after an accountable institution has filed a suspicious transaction report. Next slide, please. The proposed amendment to section 42, this requires accountable institutions to keep or to develop a risk and compliance management program that sets out all the processes or the way in which an accountable institution will comply with the requirements in terms of the FIC Act. It would also need to understand the risk that money laundering, terrorist financing, and proliferation financing brings to that institution. This provision extends the requirement to take into account for an accountable institution to take into account the risk that is associated when it comes to either new delivery mechanisms or the use of new and developing technologies. So this is to take into account, for example, issues around crypto asset service, crypto assets, as well as other financial or the new fintech sort of mechanisms that could allow for the where there could be a risk of money laundering or terrorist financing. There is also a additional requirement under clause 21 is when an accountable institution does business in a country where the country does not have the same amount of requirements, for instance, that the FIC Act has in terms of the CDD processes, that the host country would have to have measures in place to mitigate the risk of doing business in a country that does not apply the same standards as South Africa. The amendment here is for the accountable institution to inform the FIC as well as its supervisory body of the additional measures that it would take to mitigate the risk. The proposed amendment to clause 22 relates again, section 20A of the FIC Act prohibits any person from dealing with an anonymous client or a client with a false and fictitious name. The deficiency here was that there wasn't an act of non-compliance linked to that prohibition. So this is a specific definition we are addressing by now making it an act of non-compliance that will be subject to administrative sanctions should a person keep a client with an anonymous name or false and fictitious name. Next slide, please. The following proposed amendments to these clauses are the consequential amendments that I had discussed earlier, and they relate to the offences provision to when it relates to a reporting obligation in terms of section 28A, as well as when I mentioned that it just extends the requirement for the judge in terms of the RICA legislation that the act of non-compliance also extends to an order made by a magistrate as well. The consequential amendments to the Schedule 3A, which lists the domestic politically exposed persons, again, are consequential amendment because the definition of public entities and municipalities has been also included in the Act. And then Section 26 just allows for a fixing of the arrangements of the sections in the Act following these proposed amendments. Next slide, please. The proposed amendments to the Companies Act relate again to the effectiveness or the outcomes of the grey listing process, more specifically in terms of dealing with the non-compliance when it comes to companies keeping beneficial ownership information. The first proposed amendments relate to the discrepancy reporting, which is, as I explained earlier, is requiring obliged entities to report any material discrepancy that an accountable institution has obtained through the requirements of the FIC Act against the CIPC register. So these definitions are linked to that. And then in terms of the requirement, the clause 28 specifically sets out the requirement for the entities to report this discrepancy to the CIPC. And then when it comes to taking action against companies that fail to submit a securities register, the CIPC, the proposed amendment here is for them to be able to deregister a company should they not provide that information relating to beneficial ownership for a period of 2 years or more. And the other change, again, linked to the effectiveness of ensuring that beneficial ownership information is kept, is that the CIPC may now impose administrative sanctions for non-compliance with the requirements in the Companies Act relating to beneficial ownership information. Next slide, please. The proposed amendments, again, to the following clauses are linked to the ability for the CIPC to impose administrative sanctions, and it also increases the maximum amount of an administrative fine to be increased from R1 million to 10 million rand. That's the maximum amount. The consequential amendments to the CIPC being able to issue administrative sanction is for the Companies Tribunal to be able to review the administrative fine that would be imposed by the CIPC. And then the others are consequential amendments like the arrangement to the sections. The next slide, please. This proposed amendments to the Financial Sector Regulation Act, I will hand over to my colleague Rieta at the FSCA, who will take you through the slides relating to the Financial Sector Regulation Act. Can I hand over, Chris?
Yes, of course. Thanks, Purunji.
Good morning, Chairperson and honorable members. I hope I'm audible. Can I just check if I'm audible?
Yes, we can hear you. Thanks, Rita.
Thanks very much. Yes, so the amendments to provided for in clauses 35 and 36 are amendments to sections 2 and 3, excuse me, of the Financial Sector Regulations Act to strengthen the Minister's authority to designate new financial products and services. So what's being intended is to propose a more flexible definition of financial investment in section 2 and expanding the definition of a financial product in section 3. So sections 2 and 3 basically defines the scope of the financial sector regulators by specifying what financial products and financial services entail, and it enables the minister to, through regulations, designate new products or services that weren't included in the initial list. So to enable the regulatory environment to respond more effectively to market innovation, the definitions are amended to make them more neutral. In section 2, to remove the requirement for the minister or for the regulators to show that the product must be provided by a person or a company, but rather to more broadly to refer to an arrangement. Then clauses 37 and 38 proposes to amend sections 111 and 113 to provide for licensing whereby for a dual licensing process. So even where a current financial sector law or the Financial Sector Regulation Act, the National Credit Act or the National Payment System Act provide for licensing, this extended provision will enable the financial sector regulators to prescribe a standard to provide that there may be dual licensing. So just to maybe to give an example of this, currently payment services providers are regulated in terms of the National Payment System Act, and because of this provision in the FSRA, the FSCA is unable to license payment service providers and impose specific conduct provisions on them. So if it appears to the FSCA, for example, that it's necessary to provide for dual licensing to enable the FSCA to also regulate these providers, this provision will enable that. Next slide, please, Alan. So section 39 amends section 131. Apologies, it's not in the slide, but it amends section 131 to extend the obligation to provide information to financial sector regulators, also to significant owners and beneficial owners. So this provision provides, section 131A provides that the financial sector regulators may request information that's necessary for them to perform their functions from any person, but then subsection B only obliges licensed financial institutions to provide the information. So this obligation is extended by the revision to also to significant owners and beneficial owners. Clause 14 proposes to amend section 135 of the Financial Sector Regulation Act. This provision empowers the regulators to institute investigations when they have reasonable suspicions of contraventions. And the way the provision is currently written provides for that the investigation must be in respect of a specific person. Now, at the moment that the suspicion is formed, the regulators aren't necessarily aware of who the person responsible for this contravention may be, and this results in the investigation instruction to having been amended from time to time. So just to ease the process for investigations, the reference to person in the provision is removed. Thanks. Next slide, please. Then chapter 12A deals with resolution of designated institutions. Those are the banks and like. And section 166S provides that where necessary for the orderly resolution of a designated institution, the Reserve Bank may reduce an amount or that is payable under an agreement to which an institution and resolution is a party, or the Reserve Bank may cancel the agreement. So Section 169 excludes certain transactions from the application of Section 7. Clause 41 proposes an amendment to Section 166S9B to replace the reference to derivative instrument with transactions concluded under the master agreement defined in the insolvency law. This will just provide legal certainty and strengthen the Reserve Bank's powers to act or to exercise their resolution powers. Thanks very much.
Okay. Is that all, Rita?
It's all done from my side. Thanks, Chair. Thanks, Chris.
Okay, thanks very much. And thanks, Chair. There was one point that I didn't quite highlight in our presentation at the beginning, was just on the deadline for the technical compliance assessment. So the technical compliance assessment will be finalized in about November. So just so that you've got an idea of the timing for when it would be super helpful to get this General Laws Amendment Bill through. If it went through before then, it would be able to assist in our ratings for the mutual evaluation. But other than that, I think we are all covered from our side. Thank you, Chair.
Okay. Thanks, colleagues from National Treasury. Let's come to the next item, which is the engagement by members of the committee. Questions for clarity, comments, and then we take it from there. Mautwe, such a potential color, yeah, let's all. Let me take the hands. Honorable Mautwe, Dr. Beck, Honorable Beasley, Honorable Squatty, Honorable Alexander, Alan Woodley, are those the only there's 1, 2? I see 5 hands on my side.
That's it for now, Chair.
That's 5 for now.
That's correct, Chair.
Okay. Okay. In that order, Honorable Mautwe.
Thank you very much, Chair. I'm also shocked that my hand has changed. I don't know what happened. I think it's the Kwati who's sabotaging me. Chair, I've got only 2 questions. As we welcome the presentation by the team, we do so, Chair, because we live in a country where crime is the order of the day. So when we make laws, we really get excited that something is going to happen, because we all agree that we can't have the status quo continue. We have the highest crime in this country with the Phala matter, where dollars were stashed underneath the mattresses and the couches. So these amendment bills, are they going to assist us in trying to avoid what has happened, where foreign currency is found undeclared? You go to SARS, SARS says they are not aware. You go to the Reserve Bank, they say no, they are not aware of any declarations. And yet the dollars have been found. You go to Madlanga Commission, Chair, you see evidence being laid that the police are doing their job at the border gates by taking these monies that are not declared, report them to the Reserve Bank, and they get calls from the powers that release that money to the owner. So these laws that we have, how are they assisting us to curb this crime, because it's one thing to have beautiful laws and nothing happens about them. But also, when do we hold the accounting officers of these institutions accountable? Because we're going to write a law that enables FIC to do some investigation. And when they come to this committee, we ask them about the investigation. The accounting officers will say, we can't answer that question. They can't even present the reports to the public for the public to know. So what does that mean now about the accounting officer? Because it clearly means that they are part of the crime. They are shielding this crime. Especially when institutions like SARS, they've already said we don't have declarations. Reserve Bank, no declarations. But the accounting officer refuses to report matters. Why are we not having an amendment that says in such cases, the individual must be criminally charged for defeating the hands of justice? Because clearly he's part of this crime. That will be all on my side for now, Chair. I thank you.
Thank you, Honorable Motwe. Dr. Beck.
Thank you, Chairperson, and to the Treasury and regulatory team that have engaged today. I think it's important to start off by saying that I and we in the DA are not agnostic to white-collar crime in South Africa. And we know that money laundering takes place in both the public and the private sector. And so some of these interventions that are being proposed are welcome. I want to go into a few specific questions. The first is the general explanatory note. We see there on page 23, you've acknowledged that this bill will create a financial cost to the state. However, I'd love to understand whether we've done an assessment or an analysis of the financial implications for small businesses or emerging businesses. I'll give one example, but it's a more general question. And the example is, have we, for example, looked at the companies registered with the CIPC that might now fall foul? And is it 10 companies? Is it 100 companies? Is it 1,000 companies? Is it more than 1,000 companies that might face a fine of, 1 to 10 million rand escalation? And more than the financial cost, the question there is the time and confidence to be entrepreneurial in South Africa. Have we at all assessed the market sentiment around what this regulatory measure will mean for the ease of doing business? Then on to the second question, which has got to do with clause 37 and 38. And I'm quoting here, where required by a standard issued under section 113, be licensed under both the Financial Sector Regulations Act, or the FSCA, and other applicable financial sector law, the National Credit Act or the National Payment System Act, where the responsible authority considers dual licensing necessary to achieve its objectives. Now, I might not be fully au fait with exactly what's intended here, but if what's intended here is that businesses must then, at the discretion of a particular regulator or set of regulators, acquire new licenses, then it is the reality in South Africa that each of these licenses often take months or years to obtain. And often, of course, with good reason. We want to make sure people operating in spaces are adequately prepared and able to do so. But again, have we considered the implications for emerging businesses if more licenses are required? Especially if it's not clear when the sort of dual twin peak, or even in some cases more than two peaks, would apply to businesses. Moving on to the next question, again, might have misunderstood the intent of what's being proposed, but it has to do with the FIC getting lifestyle audit powers when it comes to public entities. Now, I must say, when it comes to more transparency in public entities, I think more scrutiny there is very welcome. So not opposed to this in principle, but it is my sense that we have SARS already who can do lifestyle audits. And I just wonder what the duplication risks are. Should we not rather have the FIC refer people to SARS for lifestyle audit and then give SARS a bit more money to do so? Happy to be educated on what the intent and the execution here will look like. Maybe that is exactly the intent. And then the last question, Chairperson. Again, on the general explanatory note on page 23, it indicates that so far the team of people presenting to us today, headed by Treasury, has engaged with various state bodies, the DSD, the DTI, the FIC. And I just wondered whether you've spoken to industry bodies so far. For example, the Payments Association of South Africa, I think, will be affected by this, and they might have some insights, but there are probably many other associations who would be interested. And I know we will, of course, engage with public participation in this process, but I wonder in the drafting of this, whether we've consulted with what the implication will be on industry of these measures. Chair, I'll conclude with a piece of lawmaking history in the US that I think is a maxim that we should be guided by. And I think it was Benjamin Franklin that said that those that would sacrifice liberty for security will lose both and deserve neither. And I understand fully that we want to remain FATF compliant and engage on equal footing with the rest of the world and be part of formal financial flows. But we must caution that it's important to protect liberty and the freedom of individuals and businesses to transact with each other. And of course, impose sanction where there's wrongdoing, but not get in the way of industry. And this trade-off between efficiency and certainty or security must always be top of mind. We cannot lean too far in the direction of security at the expense of enterprise. Thank you, Chair.
Thank you, Dr. Beck. Honorable Beasley.
Yeah, thank you, Chair, and greetings, colleagues, and all the others on the platform. So just once again, just to commend National Treasury and everybody else involved in getting us off the grey listing. It is imperative. I mean, whether we like it or not, whether we argue about the impact on businesses locally, if we remain on the grey list, it's going to have a massive impact on South Africa's future ability and companies investing. So whether we like it or not, we've got to comply. So just congratulations to everybody for getting us off. And the key question is, how long do we remain off it? So this question, my first question is to Mr. Ishmael Moniat and also to National Treasury. Obviously, the Madlanga inquiry is exposing a lot of corruption, particularly in the police. Is there a concern from Mr. Ishmael Moniat and also National Treasury if that could actually impact on our grey listing going forward? Because there are some serious revelations going on there about police corruption and money laundering and everything. So is there a concern that what's happening is going to impact on our grey listing? And then secondly, it'd be interesting to get the views. Is there a risk that we could face grey listing in the next imminent evaluation? And then just a question in terms of following up what Honourable Burke was just saying in terms of the impact on the business. I've got a couple of close corporations and that they're so small, but the amount of paperwork that's involved in the regulations, the beneficiary ownerships, and that. So my question is this does this apply worldwide in terms of the regulations? And because it would seem like very unfair if South Africa has to face more red tape because of our history as opposed to other countries. So is this a standard that is set worldwide in terms of actual requirements, or do they make it add further requirements for companies that are struggling with this? And then just a question in terms of the administration sanctions and criminal sanctions. Is it equal across whether you're an NGO, a CC, a PTY Limited? Because just in the presentation, it just appeared that the NGOs, the sanctions weren't too as serious. But is it consistent across all three entities? And then who actually pays the FATF? Do we make a contribution every time they come out? Who actually funds that? So I'd be interested to know that. And then, the last question is just in terms of November, if we don't get this legislation through, what would the impact be on that? And how urgent is it to get this legislation? And Chair, once again, thanks to National Treasury and everybody for this, because it is critical that we remain off the FATF grey listing. Thank you, Chair.
Thanks, Honorable Beasley. Honorable Squati.
Thank you, Chair. Chair, let me join my colleagues in appreciating the work that National Treasury is actually doing. Chair, however, I want to understand in terms of this some of these amendments, but also in terms of the application of these laws, particularly in an environment that we are in the continent, but also in SADC. I see that we're going to be having, actually, we're not going to be having already, there is this mutual assessment that is actually taking place as we speak in the Southern African AML, whatever region that we are in. I want to understand, because Chair, all these things that we're doing is going to be within this environment, and the activities, financial flows, and so on are within the region, but also in terms of the continental, environment. How many of these countries that are part to this arrangement are actually in SADC, but also in the continent? Because that then be able to speak to the impact, because you cannot apply certain standards to countries that are not necessarily party to this agreement. So I want to understand that. Or if there is going to be impact in terms of those countries that are not necessarily party to this agreement, are also going to be affected by what we are actually dealing with in terms of trade, in terms of financial flows, and so on. Secondly, Chair, is in terms of, I think Honorable Motwe went moved a bit closer to that, which is in terms of the South African environment, where you find that even those that are supposed to be applying the law are actually the ones that abuses the laws. And now, are there any measures that are going to govern that? Because most of the time you find that there is actually no laws that says that those that are utilizers of these laws, if they are found to be in contempt of the law, these are statutory sanctions that are already there, so that even when these cases go to courts, they don't take ages. I mean, you find that we are able to take a decade with one case just because we do not necessarily have those statutory positions in terms of sanctions for those that are using the law, so that you are as well able to protect. I mean, you can imagine, because these amendments are actually far-reaching, where you're going to find that, for instance, there will be those that will be allowed to go into accounts, into banks, into companies, and so on, to investigate. But now, if they are not strictly adhering, there are going to be a lot of abuses. And I think those are some of the things that we need to look at and make sure that those that are applicants that are going to be applying the law are as well being, measured in terms of their work, but also they know that there are statutory sanctions that will take place once they cross the line. The other area, Chair, is in terms of what was that? In terms of the businesses, for instance, in terms of the risk that is there, in terms of terrorism financing and so on. If in a country like South Africa, where you've got a lot of, for instance, illegal non-nationals who are actually playing their trade in the country, who obviously will not be using this, commercial or formal institutions or financial institutions, because that is where you have a lot of illicit financial flows that are taking place. Obviously, there will be those that are going through the formal channels. But then how do you then deal with those? Because I suspect that besides the compliance that we're dealing, because here I think at most we're dealing with compliance. And we does it therefore as well apply to those that are using this formal channels to deal with the financial flows and so on. Because they are obviously, we've spoken to NPOs and so on, but I'm not sure in terms of NPOs how we are going to definitely deal with them, particularly in terms of their operations. As it relates to social development, it's not really more of you financial institutions, but your NPOs and so on. I'm not sure how this is going to impact on them. Yeah, let me stop there, Chair, and hope that the work that has been done in terms of interdepartmental coordination will actually, take into account all those that are necessarily supposed to be forming part, so that we do not create confusion, but also animosity within departments. Thanks, Chair.
Thanks, Honorable Squatte. Honorable Alexander.
Thank you, Chairperson, and thank you for the department for taking us through the presentation. I know that our first technical compliance report is due in 7 weeks, the 27th of July, regarding our next FATFA evaluation. And my question is also like, what specific gaps still remain unaddressed, and what are the real risks that we face that we may not get, our timelines here are quite tight before the first technical review is done. So that's the first question around timing. But then specifically around the bills that were presented today, and as many of the colleagues have already brought up these themes, but I'd just like to reiterate. The bill is now allowing the FIC to conduct lifestyle audits of persons prescribed by the minister or as requested by any organ of state or public entity or municipality. That's a very wide definition. Without a clearer criteria, what will trigger an audit, and what is the risk for the abuse without us having a tighter definition of lifestyle audits, which is largely new and untested. And like my colleague Honourable Burke mentioned a little bit earlier, is should we not potentially consider keeping lifestyle audits within the ambit of SARS rather than creating a parallel process? Then with regards to information sharing, the expansion of the FIC information sharing to the Public Procurement Office and the broader Management Authority is justifiable on policy grounds, but the bill does not explicitly cross-reference any POPI obligations that the new sharing relationship. Given that South Africa's POPI framework, any transfer of personal information between state organs requires careful delineation for the purpose, the necessity, and the retention limits. So the bill is silent on these constraints for the new recipient. So if we could get some more clarity on that. Then just to reiterate, in South Africa, we rely quite heavily on our small businesses to grow the economy and to be the entrepreneurs that they can be to provide employment for South Africans, but we tend to strangle them with compliance. So my question would be like, has the Treasury conducted any analysis on the MPOs and what effects these new regulations may have on their obligation? The bill treats like a small church feeding scheme of, has an annual budget of 50,000 Rand. It's the same as a large international NGO moving millions of rands across our border. Both are now facing the same compliance rules, record keeping requirements, and risks are heavy sanctions. So like, what evidence is there, and are there potentially exemptions or thresholds that would be considered for these NGOs. And like the question is have we done a research or analysis on the NPO sector as a terrorist financial risk in the South African context? And what percentage of these investigations, what percentage of these investigation cases in the past 5 years have involved small businesses and the likes of NPOs? And then my final question is around clause 35 and 36, which gives the minister a broad discretion to expand the definition financial product. Parliamentary oversight mechanisms will be available to us around allowing this to happen. Thank you, Chairperson.
Thank you, Honorable Alexander. Those are the questions so far. I don't see any other hand on the platform. Okay. National Treasury, over to you.
Thank you, Honourable Chair. Thank you, Honourable Members. I'll try and go through the questions that I can answer, and then I'll pass over some to my colleagues and the other entities that are on the call with us. On the first questions of what is going to assist with undeclared foreign currency, I think the newly gazetted traveller declaration system for cash will help with that. So from 1 July, I believe, and my colleagues can correct me, there will be a requirement for this traveller declaration system where you do need to declare those amounts as you come in. On the FIC and not sharing information, I mean, just to come to the defense of the FIC, I don't think they are doing anything wrong here. By law, they are not able to share the status of investigations or whether they are even doing investigations or any details of those investigations with anyone, other than the NPA and law enforcement agencies. So as National Treasury, we don't see any of that. And they're not allowed to share that with anyone else other than those law enforcement agencies. And then it needs to be used for prosecution by those law enforcement agencies. And they can come in again as well if they need to. A couple questions on the small and medium-sized businesses, but I think it also relates to our interactions with the public and with industry. So this bill went out for comment twice. The last time was at the beginning of the year where we got comments by March. So we have had a lot of submissions from industry on those. We've had discussions with them on it. They have raised, and I can ask my team if they've had any issues on that in terms of the compliance costs that have been put forward by businesses. But then we're happy to discuss that again through the public consultations in Parliament. I'll ask the FSCA to come in about the burden of licensing and dual licensing as well. On the lifestyle audits, so SARS can do lifestyle audits, but SARS don't share lifestyle audits with anybody else. I think they do lifestyle audits to try and assess what the taxable income is. I do see some SARS officials here, and they can correct me, but they wouldn't be able to then share with other institutions. And my understanding is that FIC can then do the lifestyle audits to then assist with investigations. But it would be useful for them to come in, especially in relation to the last question on the very wide definition. Momo, I think you asked a direct question as well, so also please come in on the impact on grey listing. In terms of the standards, are they applied worldwide? So yes, they are, and they are the same. And the team goes to the FATF plenary where a lot of these discussions take place, where the standards are the same for every country. And the assessors then evaluate how effectively those countries are adhering to those standards and those recommendations. And there's very good discussions I've attended as well, and it's very useful, and everybody is treated the same way. So there is no way here that we are treated sort of unfairly, although what we have raised previously is that developing country contexts do need to be taken into account, where there are fewer resources. There is a push for growth. So we have pushed that in some of those plenaries, and some of my other colleagues can come in and talk about that if they need to. Who pays the FATF? I think it's all the members. It also relates to how many countries in SADC and how many countries are, in Africa are party to this. So in October, we got off the grey listing. And at the same time, Nigeria, Mozambique, and Burkina Faso also got off the grey listing. So they were previously grey listed. So almost all African countries are part of the same process. I think only ourselves and Morocco are part of the FATF core members, but the other countries interact through FATF through a summer leg, the Eastern Southern African Money Laundering Group. And they are going through these same assessments, same types of standards. They need to go through the same processes that we do. I think that I will ask the other colleagues to try and address some of the questions that I didn't. Maybe I can start with the FIC and then the FSCA and then Timoma and then anyone else. Thanks. FIC?
Thanks, Chris. I think just broadly to answer the questions relating to the lifestyle audits, the provisions that we are proposing is not intended to take away any of the other pieces of legislation or regulations that deal with lifestyle audits. The intention for the FIC to conduct lifestyle audits would be for it to conduct it as part of its mandate of following the money. And the information that the FIC holds would be quite different from, for example, the SARS. So it won't be specifically related to tax issues. So in that sense, the FIC's ability to conduct lifestyle audits would be based on the information that it would hold, which would be different from any other entity that would be conducting it. And in terms of the scope of the lifestyle audits, as we've explained, it would be there is a wider scope in terms of ensuring that the positions, especially high-ranking officials in the state-owned entities, would be, again, sort of like a requirement before a person is appointed, that there would be this a lifestyle audit taken. So and when we specify in terms of the Schedule 3A, that does contain the list of the persons that hold those positions. And just in terms of some of the other questions, the POPI legislation and the impact on the FIC Act. Here again, the ability for the FIC to share information would be within the POPI Act and the safeguards that are in place, or the requirements, should there be, for instance, where the FIC is, the work of the FIC may be excluded from the POPI legislation, provided that there are safeguards in place. This would also ensure that when the FIC shares information with the new entities coming in, there are safeguards such as that there would be an authorized officer that would be appointed, where that information is channeled through that a process or mechanism in place to ensure that any information that is shared is safeguarded. And then in terms of, I think the questions relating to the NPO, I can maybe pass that on to the Department of Social Development, unless there's any other specific questions that still remain outstanding. Thanks, Chris.
Thanks, Pavitra. Yes, that'll be great if we can bring Umpel from DSD in as well. Maybe FSCA, do you want to come in next?
Thanks, Chris, and thanks, Chairperson. Yes, so the dual licensing would not happen automatic. It will require the making of a standard before, And as the Honourable Member Alexander referred with the powers with regard to sections 2 and 3, this process is again subject to consultation as well as parliamentary scrutiny, and it will be a careful balance between the objectives of the Act and the authority, the financial sector regulators deeming it necessary for to fulfill their functions, and the regulatory burden placed on smaller entities. And then the FSR Act already provides for coordination and cooperation between the regulators, including the Reserve Bank and other regulators like the National Credit Regulator, where sometimes it's possible through an MOU to provide for a easier or a more streamlined licensing process, so that the institutions aren't subjected to providing all the information against for a new license application. That's just one example of how coordination can be achieved. Thanks, Chair.
Thanks very much. There was just one correction I needed to make. We were actually the only FATF core member. Morocco aren't actually as well. So it is just us as the main African representation. Paul from DSD, can I please bring you in?
Thank you so much, Chris, and good morning to the honorable members and colleagues. From the DSD side, there was a question asked in terms of NPOs complaining about the compliance. I would just say prior to the whole process, DSD did conduct an impact on what are the compliance issues that are affecting NPOs not to adhere to compliance. So what we found out, and this was in 2018, that there's a compliance burden that is based on NPOs, but as a result of lack of integration from the regulator side. So from then on, we started to integrate in order for NPOs not to experience the burden of compliance. So when the FATF process came in, already we had started to ease the burden of compliance, but also to categorize NPOs in terms of their ability to comply. So there is that process of ensuring that compliance does not mean you have to have money, but just to ensure that you are accountable and there is that transparency from NPO. So this is part of the work that DSD is embarking on. So on this particular process, where we specifically have to employ a targeted risk-based approach. So what we had begun doing is to do an analysis of NPOs that are already registered. And this analysis just to identify which NPOs are at risk, because not all NPOs are at risk, which NPOs are at risk and has the potential to be abused. So that process is assisting us to identify them. And this is based on the methodology that would have embarked on the risk assessment to identify what are the risk indicators, what are the characteristics, and then we measure those against such NPOs. And these NPOs would not automatically be penalized, but there would be a process of making them aware of them being aware that they are at risk of potential to be abused. And we employ and assist them to put measures in place to protect themselves. So in the instance, so there will be a continuous awareness, a continuous relationship. Hence, we have to strengthen our monitoring arm to ensure that at least we engage with them at an intensive level for them to protect themselves. And being aware that we don't have to disrupt the work that they do, because we have to make sure, and this is what FATF is advocating for, don't disrupt the work of NPOs and don't put a blanket process just identify only those and work with them, because the fact is NPOs are providing good work in communities. So we are well aware of that, and we train them to know how to defend themselves. So the issue of penalties would only come when there is a non-compliance, repetitive non-compliance, which will begin with administrative sanction even before we get to the last leg. So there would be a process before it gets to the penalties, but then there would be evidence of the processes undertaken by the department before we even get to the last leg, which would be the penalties. So I hope this assist. Thank you so much, Chair.
Thanks very much, Umpol. Mohammed, there was a question directed for you.
No, thanks. Morning to Honorable Chair and members. On the question on the impact of the Madlanga Commission, the hardest immediate outcomes or effectiveness measures are sort of IO7, which is on investigations, prosecutions, and convictions with regard to serious and complex money laundering. There's one for terror financing as well, IO9, and IO8, which is related to asset forfeitures or asset recoveries. Those are, I would say, the hardest measures that South Africa will need to deal with. And clearly, I think the events at Madlanga, the ability of the country to deal with organized crime, and particularly if many of our top police are implicated in their links with organized crime, does impact on their ability to process cases. And if these cases are not completed, that will impact on South Africa. FATF looks at 5 years of data. So it wants to know the number of cases, how many of them have been fully investigated, whether we prosecute in such cases, whether there are convictions, and so on. And I think that's where those measures, I think, are going to be quite tough for South Africa to deal with. It's not a secret that I think that's the area of law enforcement, I think, is one of our biggest challenges, particularly as they relate to financial crimes. So in a sense, I think both the grey listing and the coming mutual evaluation does pose a challenge, an opportunity for us to fix up our system and to make sure that we do better against financial crimes. I also just want to deal with one or two other quick issues, Chris, if you don't mind. There was a question on illicit flows between countries. We are also separately, and it was in the slide, we don't need legislation for it, but there's one of the FATF recommendations we partially comply with is called Recommendation 32. So those are the signs when you go through an airport that say in Europe or in the Americas, it would say if you've got $10,000 or more in cash or euros, you've got to report it. So that will come in place. The president has signed, I think, approved a proclamation which was published last week, and that should take effect from the 1st of July. So that will deal with that issue. The other issue which I thought would be just on the technical compliance deadlines and this particular act, we've said that technical compliance is low risk. So, we don't think we'll be grey listed because of problems with our technical compliance. But the issue is if we can get this bill in time, ideally it should have been in place obviously before the end of July. But even if it's in place by September, October, it would help us not just on technical compliance on the margin, but it would help us with some of the effectiveness measures. So that's, I think, the importance of this bill. And the last issue that I thought I would just touch on was a question on many countries in Africa and their participation at FATF. Though they're not members, every country belongs to regional formations. So in Southern and Eastern Africa, we're all members of ISAMALEG, a body called ISAMALEG, or that's the acronym. And they too go through mutual evaluations, but through the regional body. Technically, our mutual evaluation is being done by both the FATF and ISAMALEG. And typically, we find that there are about 20 countries that are grey listed at any one time, and almost half of them tend to be from our continent. We have fought hard at FATF for FATF to have a more developmental approach and to look at the problem of these low-income economies particularly. And FATF has taken steps to try and make the mutual evaluation process a bit easier for developing or for poor and developing countries. Thanks, Chris. Over to you.
Thanks very much, Momo. Can I also please bring in Lucinda from the CIPC, who can maybe chat to a couple of the small business issues.
Thank you very much, Chris. Good morning, Chairperson, honourable members. Lucinda Steenkamp from the CIPC. I would just like to touch on a few of the questions that were asked specifically with regards to the burden on small businesses and the ease of doing business, and this compliance requirements that have been elevated through the beneficial ownership declaration filing processes. And what I can indicate to the committee is that CIPC has implemented several enhancements with regards to the beneficial ownership register, which we call optimized filing, which allows for smaller entities to submit their whole declaration online and declare online, and the information extracted is extracted from the CIPC records and pre-populated in terms of their declaration requirements. So that eases the process of the beneficial ownership declaration filing. And then the second one that I would like to touch on and hopefully answer the question of the honourable members is the question surrounding sanctions. So the purpose of the sanctions is deterrence, so that the administrative fines implemented by the CIPC, the authority provided to the CIPC to do that through this piece of legislation, is more of a deterrent to compel entities to comply with their legislative requirements. And also the question that was asked about if the sanctions apply across board to all entities. So it's not a one size fits all. The Companies Act specifically provides for certain criteria that needs to be taken into account when there is the process of sanctioning a company for non-compliance, such as the nature and duration of and the gravity of the contravention, any loss or damages suffered as a result, etc. So there are specific criteria being applied to these entities that at the end of the line do not comply with requirements. And before we get to the step of administrative fines issuance, there is compliance notices issued and a whole process that needs to be followed before that. I hope that answers some of the questions with regards to that. Thank you very much.
Thanks very much, Lucinda. I think that covers everything from our side. Honourable Chair, we're happy to take any follow-ups if required. Thanks.
Thank you. Are there follow-up questions from members? Dr. Berg?
Thank you, Chairperson, and again to Treasury and the team for attempting to answer some of the questions that have been posed. The theme of my follow-up, Chairperson, is to do with the streamlining of work and making sure that we don't duplicate and silo efforts. and in so doing hamper the ability for businesses to operate successfully within our borders. The first example I want to zoom into is almost more of a policy question. One of the challenges we're seeing is that NPOs, including, for example, trusts, fall under the Department of Social Development. But trusts are very often used for financial transactions or moving money. Now, we are not, as the Standing Committee of Finance, the Portfolio Committee for Social Development. But from what we hear, things are not okay in that department. And so I have a policy question there, fitting into this theme of streamlining work. And that is, should we not consider moving some NPO oversight above certain thresholds, perhaps, to the Department of Finance orbit and to Treasury for oversight? The similar question about siloing of work, the answer back from the Financial Intelligence Center seems to be that they're not trying to take away powers from other regulators and enforcers such as SARS by spinning up their own lifestyle audits unit, if you will. But that wasn't the question with respect. The question with respect is, does it make sense for us to have multiple... Well, maybe before I ask the question, I must preface this very clearly. I will be the last person to stand in the way of imposing more transparency on officials, especially at the higher echelons of public entities. So you are commended in that effort and encouraged to pursue it. The question is about the efficient route of pursuing that transparency, and whether having multiple regulators and entities with these units inside them doing, for example, lifestyle audits is the most sensible approach. Now, I understand what you're saying. You're saying that SARS might not have the level of granular insight on certain things that you as the FIC might have. But my question stands is, if all of these functions are effectively devolved oversight functions from Treasury, then at what point do we think of making our work less siloed and more streamlined, so as to, one, preserve the cost implication for the state, but two, also preserve the cost implication for the individuals subject to this oversight and transparency that you're trying to implement. And I must stress this point. It is really important that we get this right, and it's really important that we don't let people off the hook who are doing dodgy things and pocketing, especially public money. But as we've said earlier, also from the private sector, stealing that's happening there. But the answer cannot be to shift the burden to a tired population. So that's my question. And maybe a final question, especially for a question especially for Mr. Axelson. Is it our sense that it's Treasury's job to create an environment that grows the economy? And I wonder, from the initial draft of the legislation now before us to the version we actually have, what measures have you implemented to unleash the economy as opposed to constraining the economy? Thank you for now, Chairperson.
Thank you, Dr. Berg. Any other follow-up question? Okay, thanks. Back to you, National Treasurer, and your colleagues.
Thank you, Chair. So on the NPOs and trusts, I think we can note that and take it away. I think the trusts are under Department of Justice already, so they might have a slightly different framework, but we can consider that. I think I see your point about the lifestyle audits. It's about saying, well, why not have one institution doing lifestyle audits, then potentially a few? I'm just checking with my SARS colleagues about that, because I think it's a very different outcome that they're looking for. But maybe the lifestyle audit is quite similar in and of itself. So maybe I can ask FIC if you want to come in and do a return answer on that. On the last question, it certainly is Treasury's job to try and grow the economy, which is what we want to do. What measures have we done to try and unleash growth, I think is a much wider question. In these cases, in these bills, what I can say is we do have top of mind is that we don't want to unnecessarily burden businesses where we don't need to. I mean, so on the small businesses, for example, a lot of what FATF are asking for is about risk-based assessments. And if the risk is low, the compliance doesn't need to be high. The compliance can also be low. If you are an accountable institution, it is slightly different because then you have a lot of responsibilities about sharing information, sharing suspicious transaction reports, etc. But if your risk is low, there is no need to overburden you. And we do take that into account. Because we have a lot of consultation on these bills, we certainly do get feedback from industry when they say this is just too burdensome and there's too much. And we're always open to reducing that. So in these cases, we do try and find the balance. We don't want to create obstacles where we don't need to. But also I think being off the grey list is a big positive that we need to try and hold on to. And the potential benefits to investment and growth and everything else are really important, and we don't want to undermine that either. There are lots of other measures that we're going to try and do to unleash growth, but I won't talk about those here. If I see, do you want to talk about the lifestyle audits again and have a come back? Thanks.
I think maybe just to add on is that when it comes to the intention of the lifestyle audits, it's I think here it's very specific that we are adding just an additional tool that the FIC is able to utilize in terms of the information that it holds, and that and also to achieve its objectives, which would be very different from, for example, where the SARS objective is following a different line. So here we just again proposing to have just an additional tool for the information that the FIC holds to be used to its optimum. Thanks.
Thanks very much. Yeah, just, I mean, quick feedback from SARS. It's just that their view of lifestyle audits is quite different. They're looking for unexplained income rather than sort of illicit income. And they can't share anything, so they're bound by their secrecy provisions. But I think if you're exploring it, it would obviously be about changing those provisions. Thanks, Chair. I think we're done from our side.
Okay. I don't see any other follow-up question from members. Before I close the meeting, let me check if we have got announcements. Announcements, Alan, Tebucho.
No announcements as such, Chair, but just to indicate, next week is a constituency week, therefore there's no committee meetings next week. Thanks, Chair.
Okay. Honorable Van Rooyen.
Good morning, Chair, and a very good morning to all in attendance. Chair, maybe before you close, Chair, please don't forget to outline the process to be followed, just to make sure that we understand how far is this whole process before it is brought to its logical conclusion. I'm asking this mainly to check on the prospect of further technical submissions on the mooted amendments, because of course we need to engage also legal brains around some of the mooted amendments. So if you can just outline what will be happening now before this matter is brought to its logical conclusion. Thank you, Chair.
Thanks, Honorable Van Rooyen. Okay. Okay, let's go to the last item. Thanks, honorable members. and colleagues from National Treasury, and Momo, we're happy to see you. I haven't seen you for a long time. I can see that Fataf is even taking away your hair now. But well done for what you guys have done to take the country out of the grey list. So let's start from acknowledging that a lot of work has been done to take the country out of the grey list. So we commend everybody across all the departments and across all the entities. It is National Treasury which is taking a lead, but grey listing is not a National Treasury competence. It's a multidisciplinary competence. Even Parliament is involved, everybody. So we commend every department, every official who was involved in making sure that South Africa is taken out of the grey list, to make sure that we have got a good standing out there in the international environment. In terms of the process, I hear what Momo and Chris are saying in terms of moving fast. We'll do so, but in a manner that complies with the Constitution and the rules of Parliament. This is a multidisciplinary kind of a process. And in a situation like this, we have to comply in terms of Rule 169 of the that talks about conferring powers of committees. So that rule outlines what we're supposed to do, because here we're not dealing with the exclusive powers of SCOF. We're dealing with what we call transversal issues, or transversal powers of various committees of Parliament. So in that regard, SCOF can't take decisions alone. That is not allowed. If we do that, the bill that we are going to pass will be illegal. It will be challenged, and it will be declared null and void by the courts. So we have to process the bill in such a way that we comply with the Rule 169 to confer with the other committees. So we'll do things in a manner that is inclusive, procedurally defensible, and sensitive to making sure that what we are doing cuts across various several portfolio committees of Parliament. For instance, the fact that the bill amends the NPO Act, the Close Corporations Act, and so on, it means that we'll have to have a meeting with our colleagues from social development, because NPO Act belongs to that department. It does not belong here. Close corporations and so on, the Companies Act belongs to trade, industry, and corporations. The trusts belongs to justice. So we'll have to, within whatever space of time, create space for formal meetings with those colleagues from those committees, to take them through that these are the issues that you are proposing should be amended, because we can't just on our own as a Standing Committee on Finance amend NPO Act. I think that would be illegal. As much as it's a General Laws Amendment Act, but it will not be proper for a SCOF just to promote itself and behave as if it's a super committee of Parliament. It will not be right to our colleagues. So we'll create a schedule with the management team of SCOF, that is the support team, to talk to chairpersons of social development, chairperson of trade industry and corporation, chairperson of justice. I think for now, those are the three other committees that we should engage. If there are other committees, we'll look at that and propose a joint meeting with them, and they be taken through the issues that you have raised with us, and see how we amend the clauses that are in those legislations, be it Companies Act, be it a Non-Profit Organization Act, and then of course CIPC is here. It falls under the DTIC, and we'll talk to the minister that he should do the same, and I think he has done that with his colleagues in the executive, so that they are not left behind. If you remember, Chris and Momo, last time we had serious issues with the security cluster. They were not happy in the manner we're dealing with things. If you remember, from the finance side, there was a lot of progress, but from the justice, the progress was quite slow because they were not comfortable in the manner that we were proposing to amend certain clauses in the legislations that they administer. So that is a process that, colleagues, we are going to embark upon. We'll also have to bring on board the South African Reserve Bank. Of course, Reserve Bank reports to our committee, but it's an independent body that deals with issues of exchange of money between countries and so on and so on, and the challenges that we are facing in terms of payments. There are many payment systems that are in place today. How do we deal with them? Fintechs and so on and so on. You remember last time we went to the Reserve Bank for oversight visit, but they have to come on board on this bill and give their view as an independent institution of the state, because they play a very crucial role here. I will propose, I'm not sure, Chris, how far we are with the formation of the presidential, what do they call it? I think it's a presidential team on illegal flow and whether counterfeit goods. You'll give me the right title of that committee. I think we must meet that committee. This issue of illicit financial flow, it doesn't seem to be going down. We are having lots of problems. We are having so many informal traders all over the country, even foreigners and so on, who are not licensed. And you can see that the South African population is not happy with undocumented foreign nationals who are here and who are even conducting business in this country. We can't ignore what the public is raising and think that whatever they are doing, they are marching. Of course, there are other things that those who are marching are doing which are illegal. But let's face the fact that the issues that they are raising, most of them are genuine. That and a foreigner who doesn't have necessary documents conducting business in our country should not be allowed to do so on the expense of South Africans who go through a long process of applying for a company through the CIPC. You have to comply. You have to go to SARS. You have to comply, pay taxes, and do all the things. Boom, they come into the country, no CIPC, no tax, nothing. Then they are trading. So let's meet that committee and get to understand what is it that they are doing to deal with issues that the country is facing of too many illegal traders on the streets, on the pavements, containers. If you go around townships, you go around villages, people have erected containers where they are doing business there. So we'll make sure that all the major stakeholders are consulted in this regard. We hear that we have got the problem of pressure between July and November. It's not a problem. We dealt with this matter last time in a manner that was meticulous, but in a short space of time. But we don't want to leave anyone behind. But before I close, Chris or whosoever, what is that presidential team that has been created on illicit financial flows and counterfeit goods and whatever?
I think it's
What is it?
the National Illicit Economy Disruption Program that was announced by the president earlier in the year, I think.
Okay, thanks, Chris. Let's do like this, Chris. Get us the details of that committee, who coordinates that committee or who is the leader, and send it to Secretariat Alan Tebogo. We must meet that committee. Remember, we've been to Beitbridge, we have been to OR Tambo, we have been to the Durban Harbour, so many things happening there, and we went to SARS. But be that as it may, things are still tough when it comes to illicit trade in this country. So please, because I remember whether it's the Secretariat or it's the coordination, is with National Treasury, as much as it is called the presidential team, but National Treasury is is the core department, making sure that it provides leadership in that committee. So we must meet that committee before we pass this act to understand what is it that they're doing on issues that the South African population is raising. Our economy has got lots of challenges, but there's a lot of money that is being made in this country and leaving this country. I know when we start dealing with this bill, NPOs are going to raise issues. You remember last time they came heavy on us on a number of issues, including churches. They came to this committee and raised very, very serious issues. So social development, you are here, you say you will address the issues that they are raising, fine. Let's find a way of accommodating them. So that's that. So we'll structure a program to engage everybody in the line of making sure this bill is passed, because this bill is called general laws. So it's not one law, it's many laws, and one is many laws. It means it's transversal. So we have, in terms of the rules of parliament, have to confer with the other committees. So let's adjourn the meeting. We'll meet the next time we meet, Alan, is in when we deal with the public hearings on what is it, on the 24th, on the special pension amendment bill.
Chair, before that, there's a meeting. If I can just open the committee program, give me a second. So on Tuesday the 23rd, there's a meeting, briefing by National Treasury on public finance management systems modernization, IMF legacy issues, PERSAL modernization, e-procurement, Mzansi exchange, transversal systems, and digital government. That's on the 23rd, and on the 24th is the hearings on the special pensions amendment bill. Thanks, Chair.
Thanks so much. Until we meet again on the 23rd and on the 24th. Thanks.
Thanks very much, Chair.
Recording stopped.